Um, Good afternoon, everyone. Welcome. My name is Sophie Tsang. I'm a residential real estate broker with Compass. I'm the host of this webinar. Thank you for joining us. So, as mentioned, I am a residential real estate broker with Compass. I'm based in Palo Alto and San Francisco. Service the Stanford Circle area up to the city. I have been in a business for 23 years and have helped all types of clients buying or selling their properties. I am a certified residential specialist, which is about 3% of the real estate professionals. I am probate certified as well. And I have a huge network of attorneys, CPAs, financial advisors, senior care professionals. Recent years, I have worked with clients that are in their 80s and 90s to sell their long-time homes or do 1031 exchange out of rental properties. With more and more needs in the older adult space, I got certified as a senior advisor and created the Legacy Home Transitions platform to serve our clients better. Compass, as a lot of you know, is number one brokerage in the country, and I'm a member of Compass Plus, which is a network to help older adults and their families navigate life transitions with care, expertise, and a national network of real estate agents required to earn their certification of certified senior advisors from the Society of Certified Senior Advisors. We had to go through training, pass an exam, and get background checks before we can join the group. They also redo the background check every few years. And today I invited two people in my network to speak to you their specialties. The first speaker is Mika Domingo. She is an experienced trust attorney. And the second speaker is Avery. She is an elder care strategist. So I'm gonna let Mika take over the floor.
Thank you, Sophie. Welcome, everyone. And thank you so much for being here today. I'm Mika Domingo, founder and managing attorney of MS Domingo Law Group. Our office is located in downtown Walnut Creek, and we assist families across the entire state of California and have appeared in 22 counties. I'm excited to spend this time with you. Today, we're going over some topics that I truly believe everyone, regardless of age or wealth, needs to think about. We are talking about protecting yourself, protecting your loved ones, and making sure when life gets hard, there's already a plan in place. We'll also joined by Avery afterwards, who is a professional fiduciary who will share his perspective on what happens when these documents need to be put into action. So let's dive right in. Before we get started, as our disclaimer, a quick but important note. What I'm sharing today is educational and informational. It is not legal advice tailored to your specific situation. Every family, every estate, and every set of circumstances is different, and what works for one person may not be the right fit for another. So if anything I share here today resonates with you or raises questions about your own plan or lack of one, please reach out. That's what we're here for. A little bit about me. In addition to being founder of MS Domingo Law Group, I am also was appointed as a commissioner on the San Francisco Assessment Appeals Board. And I've also been honored to be named to the Super Lawyers list for 9 consecutive years, which recognizes the top 5 attorneys in estate planning, probate, and trust litigation. And I share this bit of information not to boast, but because I want you to feel confident that the information I'm sharing comes from years of real experience working with real families navigating these exact issues. So our practice areas are in estate planning, probate and trusts and estate litigation, trust administration, and conservatorships. As for my team, I'm very proud to introduce our wonderful team. You can see their faces on the slide. We have a talented group of associate attorneys, our firm manager, Tony, our legal assistants, and of course our of counsels who bring deep expertise across different areas. Each member of our team is committed to treating clients with care and attention. We know that when someone comes to us, they're often dealing with one of the most stressful situations of their lives. And yes, I'd be remiss if I didn't introduce Theo, our Chief Morale Officer. He keeps the whole team going. So let's start with conservatorships, because this is a topic that often catches families off guard. How many of you are familiar with conservatorships by a show of hands? A conservatorship is a legal arrangement where a court appoints someone, the conservator, to manage an adult's personal or financial decisions when that adult can no longer safely manage those things themselves. This might happen because of dementia or a serious accident, a mental health crisis, or another condition that affects a person's ability to function independently. It is not a process courts take lightly, and it's not something that's triggered automatically. It requires filing a petition, a court hearing, and a formal finding that this level of intervention is truly necessary. It is always a last resort, and we'll talk about that in a moment. Temporary versus general conservatorships. There are 2 main types. A temporary is designed for urgent, immediate situations. So imagine someone has a sudden medical emergency and decisions need to be made right away. This type is limited to typically 30 to 60 days, although can be extended depending on the need, and the conservator has limited authority. A general conservatorship, on the other hand, is for long-term and permanent needs, and there has to be a showing of significant ongoing impairment that isn't going to resolve. The conservator in general conservatorship has broad authority. Here's an important practical point. In most cases, both petitions are filed at the same time. The temporary conservatorship bridges the gap and allows immediate decisions to be made while the court processes the longer-term general petition. You usually can't file for temporary alone. They go hand in hand. Now let's talk about this next one. It's very important. It's the least restrictive means. This is a principle I want everyone to walk away remembering. A conservatorship must be the least restrictive option available. So what does that mean? So courts will not grant a conservatorship if there is a less intrusive way to help someone. In other words, what other issues have been resolved and still need to be resolved? And do you really need to go that route, right? That might mean a power of attorney is sufficient, or that a trusted family member can step in informally. Could those be taken care of, those issues be taken care of that way? So what you want to ask is this really necessary? Because the court is going to ask, and the court is going to want to see a showing that there is no other way. So this standard doesn't go away once a conservator is appointed. It continues throughout the conservatorship. Conservators are required to regularly demonstrate to the court that their involvement is still necessary and still the least restrictive option. This is a safeguard designed to protect the individual's autonomy and, of course, dignity. How about selecting a conservator? You might be wondering that by now. So if a conservatorship is necessary, choosing the right conservator is incredibly important. This is someone who will be making significant decisions about another person's life, health, and finances. So you want someone who is trustworthy, highly organized, and genuinely capable of handling that level of responsibility, because it is a significant responsibility. And when families are involved, dynamics can get complicated, right? There can be disagreements, competing interests, or simply a situation where the family member may or may not be the right fit. So in those cases, a licensed professional fiduciary can be a wonderful and, let's face it, neutral option. So Avery is going to talk a lot about that during his segment. He can speak to this firsthand. Avery brings expertise and objectivity and accountability, and those things are very important as they actually reduce conflict and protect everyone involved. Moving on now to a brief discussion on trusts, and those of you may be already familiar with trusts and have your own trusts, I hope. I like to describe a trust as an instruction. It's an instruction manual for your assets. It tells people what you want to happen with your property, both during your lifetime and after you pass away. So you might have heard revocable trusts, right? That's when people think of trust, they think revocable trust. It's the most common type that we work with. While you're alive and well, you serve as your own trustee. You're in control of the assets in your trust. You can make changes to it whenever you want. You also name a successor trustee to step in when you're no longer able to manage things yourself, whether due to incapacity or death. And one of the biggest benefits of a trust is that it allows your estate to avoid probate, which is a court-supervised process of transferring assets after death. Some of you might already know probate is public and can be slow and can be expensive. So a properly funded trust sidesteps that entirety. So let's talk about who is a trustee and what goes on in a trust. The trustee is the person responsible for allowing the instruction in your trust, administering and distributing your assets. And certainly you can choose a fiduciary as well to serve as your successor trustee. So choosing the right trustee is just as important as setting up the trust itself, because a trustee has a fiduciary duty, meaning they are legally obligated to act in your best interests and follow your wishes as expressed in your trust document. They cannot act for their own benefit. When family dynamics are complicated, maybe there's conflict between siblings or concerns about one person having too much control, a licensed professional fiduciary can be an excellent option as a successor trustee because they bring neutrality, professionalism, and expertise in managing and distributing assets responsibly. Let's move on now to funding a trust. Once you have a trust, you've selected your agents, you've selected your successor trustee, maybe a fiduciary in that regard. It's important to emphasize here what funding a trust means. Creating a trust is only half the battle. The trust must be funded to be effective. Funding means actually transferring ownership of your assets into the name of the trust. So even if on your Schedule A of your trust, you list your house, and then you sign the trust and you're done, you think you're done, you're actually not done because you haven't properly funded your trust. That means making sure there's a trust transfer deed that is recorded in your county. If you have bank accounts, investments accounts, you'll need to work with your financial institution to retitle those accounts if you want them in your trust so that they are held in the name of the trust rather than your name alone. What happens if your assets that are not in the trust, they're listed, but they're actually not properly funded into your trust? Well, they may still go through probate, which defeats the whole purpose, doesn't it? But there are also other mechanisms that can be used, such as a Hagstad, which is outside the scope of today, but can be discussed at a future webinar. But for us, we always make sure when we work with families in their trust, we always make sure we have a really important discussion about trust funding, because we want to make sure that trusts are not only well drafted, but they're also properly funded. So since we're talking about the trust, it's a testamentary instrument. The other really important document, of course, we've all heard about this, your will, right? It's one of the most fundamental estate planning documents you can have. Unlike a trust, a will doesn't do anything during your lifetime. It becomes effective at death. And it states your wishes to how you want your property distributed. But keep in mind that will and the trust go hand in hand, because you could write something on your will and that asset is not transferred into your trust. You could still go into probate. More on this, if you want to learn a little bit more, feel free to reach out to us and I'd be happy to talk more about the details surrounding will versus trust and funding. So what can you do with your will? A will has some flexibility here. You can designate specific beneficiaries for tangible personal property. Those items, heirlooms you want to give to specific individuals, that would be a place to make sure that your intent is represented on paper. Okay, so later on, you would say, Mom said I could have this. Well, does it say in the will or not? Next document that is also probably very familiar to most of us is a power of attorney. We call that the POA or DPOA, durable power of attorney, which is also a powerful planning tool that you can have. And one of the most important because it helps you designate an agent. Sometimes you hear the term attorney, in fact, same thing, right? And that person can make decisions on your behalf when you're not able to. So depending on how it's drafted, a POA can cover sometimes healthcare decisions and financial decisions and bill management, buying and selling or managing real estate, and even decisions related to businesses you own. The next slide talks about what you can do with your power of attorney, and there are powers allowed by the probate code. You can define the scope of that power. You don't have to put everything there. It really depends on your case. So you might also have a triggering condition there, which is usually incapacity, right? Which is defined as the inability to make or communicate decisions for yourself, whether it's because of an illness or injury or cognitive decline. Moving on to the next document, which is the Advanced Healthcare Directive. This is also an important tool. Your whole estate plan, that whole package is very important. It's arguably the most personal document in your estate plan because there are some things that are covered there that really speak to your wishes when it's the end of life, and usually decisions having to do with what the doctor can and cannot do. So this is a very delicate topic, and when we do our advanced healthcare directives, we have a very comprehensive draft. We draft questions that are really specific to ensure that we are capturing exactly how you envision this end of life, and that you provide us with your thoughts on your preferences. So this document is so important because it takes the burden off of your family, right? Your family members might not know specifically what you would have wanted or what you would want, and you're in a position where you can't really communicate, right? So very important. What can I do with my advanced health care directive? You can be as specific as you want with medical treatments, procedures, or interventions that you consent to. Now, going into the next slide, which is choosing an agent. Again, Avery will talk more about this. Across all these documents that I talked about, your trust, your will, your POA, your advanced healthcare directive, you'll be naming agents. So usually you start with your spouse, or you don't have to, but usually that's what most people do, their spouse, their child, their sibling, or close friend. That's a good starting point. But I do want to stress the importance of making sure you're looking at the idea of having a professional fiduciary as a sometimes it ends up being the most ideal choice. Now, we talked a little bit about probate. Well, initially conservatorships, trust, and probate. And because of time, I just want to briefly talk about, alternatives to probate. As I mentioned, probate is very, very expensive and slow process and very public. There are some alternatives to probate, but it really depends on the facts of your case, right? The situation. So let's talk about the spousal property petition. This is a tool, form that you can complete. California allows this. I learned recently, helping with a matter in Oregon, that this is not Oregon doesn't usually do this, or the small estate affidavit. So this petition allows the surviving spouse to transfer community property without going through the full probate process. So the petition would describe the property in question, explains why it should pass to the surviving spouse, and establishes the community property nature of the asset. The other one I had mentioned is the small estate affidavit. It's also an alternative to probate for smaller estates. California offers this simplified option. It's a sworn legal document that allows someone to claim assets from a deceased person's estate without going through probate. And the other one is now getting more common these days, is the petition to determine succession to real property. And this is for real property specifically. That's another alternative, a court process that allows a successor to petition for title to a property. Perhaps Sophie has seen this because she works a lot with real property transactions without going through the full probate, as long as their property falls below a certain value threshold. And if you qualify, this can be a significantly faster and less expensive path to transferring real estate to the rightful heir. So as you can see, there are quite a few tools here, quite a few topics that we can dig deeper into if we have a little bit more time. But I wanted to make sure that we cover some of the important ones today. Thank you so much for your time. I hope this gave you a clear picture of the tools available to you to protect yourself and your family, and maybe spark some questions about your own situation. With the time, Sophie, did you have time for a Q&A? Or shall we move on to Avery first and do the Q&A later?
Mika, thank you very much for the presentation. We do have a few minutes. If anyone has questions, you can type in the chat or unmute yourself to ask Mika the question. And Mika, I know a lot of the questions they may have may be very personal, and it is understandable if it's not a generic question, they may want to get in touch with you. So Mika's contact information is showing on the screen right now, and you will get a copy of the recording. If for some reason you lose her contact, feel free to reach out to me as well. There's a question in the chat. How about caregivers in a will or a trust?
Let me clarify. If the question is asking whether caregivers can be designated in the instrument, is that the question? Or is there another more specific to the idea of caregivers in a trust? Did you mean can they be designated, or just so I'm answering appropriately?
And Mitos, do you want to unmute yourself?
So, in terms of designating a caregiver in a will or trust, testamentary instrument, if the designation is as to the caregiver serving as an executor of the will or the successor trustee of the trust, uh, that sometimes happens. And the formality of validation of the will, right? What makes a will valid in California and the trust have to be followed. Now, another thought I have as you ask that question is sometimes caregivers, they do quite a bit of work, right? They really do quite a bit of work for the settler and the surviving spouse. And sometimes the caregivers have are designated as beneficiaries. And so there's nothing in the law that prohibits that. Although I will say that under the Welfare and Institutions Code, if a caregiver is designated as a beneficiary, there is a presumption of undue influence that has to be overcome. And one thing that can really protect the settler's intent in maybe providing for a caregiver is to have what we call a certificate of independent review. And that would be in addition to the drafting attorney, there is another attorney who does an independent review of what was done by the other attorney, who conducts some research and an interview of the settler when they're creating their testamentary instruments to make sure that the intent is consistent as what was represented by the drafting attorney. There are protections in place, but yeah, caregivers, we acknowledge them. They do quite a bit of work, and we want to make sure they're protected as well. Thank you for that question.
Thank you very much. Any other questions for Mika? If no other questions, I know you had court this morning, Mika, and a very busy schedule. You're welcome to stay, but if you don't have time, that people can reach out to you later on.
Sophie, I had planned to stay to support you and Avery, of course, and if I may also encourage everybody to check out Mika Minutes. And Sophie is our current guest there, and it's accessible. No need to pay for anything. YouTube Mika Minutes, and there's a lot of information there that might be helpful for you. So please feel free to check out Mika Minutes on YouTube. It's also available on Spotify. Thank you, Sophie.
Great. Thank you so much, Mika. So before I bring on the next guest speaker, I would like to share just one screen. The service platform that I created is Legacy Home Transitions. Christine, can people see on the screen?
Yes, Sophie.
Okay, great. So as you know, I help people buy and sell properties. And for an older adults or long-time homeowners, before they can actually get to selling the property, they could be a lot of steps before it. They may be downsizing or right-sizing. They may be moving to a senior facility. They may be coordinating with their family members to decide what to do with the property. And oftentimes it's more of, I have so much stuff that I don't want to throw them away because they all have sentimental values to me. So I have vendors who can help clients sort through those properties and allow their family members to come collect them and preserve it in the family. And a lot of times selling a rental property or selling a long time home in the family, you it's best to talk to a tax professional to make sure that any tax that will be required or the timing of it to preserve the value. And when the property is ready for me to step in to do the market preparation, to do the design and staging and design the strategy to put it on the market, that's when I can really shine in the process. But the platform is really to allow from the beginning to the end that the clients feel like they have a say to where things go and they have control of the timing and they can incorporate their family's opinion and recommendations into the process. So let me stop sharing. The second speaker is Avery, and he is an elder care strategist. Really, not a lot of people in this field have this specialty, so I'm very excited to introduce him to the floor. Avery?
Hello, everyone. Thank you so much, Sophie, for hosting this. I wish more people hosted webinars like this for everyone. And thank you, Mika. That was an absolutely amazing job of going over a lot of information quickly that's so important. So let me share my screen here. Let's see if I did this correctly. Okay, and can everyone see my screen? Okay.
Yes.
Okay, thank you. So I do apologize in advance. I have been really struggling with my internet today, and I've got a long wire running to the router right now. So if it cuts out, please forgive me. I will switch to my cell phone hotspot and rejoin. But it seems stable right now. So I am an elder care strategist, and I'll explain a bit in a second, but I'm also a professional fiduciary by licensing. And this presentation, I think Sophie and Mika and I, we just thought it would really go well together because now you know what to plan for, what to think of. And the next question is, who is going to be managing everything? So just a quick disclaimer, I do not provide legal, investment, tax, or placement advice. I provide a consulting service, and this is just general educational guidance. And Mika is the expert for the law, and Sophie is the expert for real estate. A bit about me. I like to say that my first career was caregiving. And I was in my junior year at UC Davis, and I got the call that my father was in the hospital. So I rushed to the hospital, and that's when it all started for me. So my father is fine now, he fully recovered, but there was a bit of a rocky period where I helped him manage his finances. He had 2 houses that had quite a bit of deferred maintenance because he was always working, and so I helped him sell those houses, get them ready for sale. And shortly after I helped my father through all of those challenges, my mother-in-law developed dementia through the pandemic. And so we cared for her at home all the way through to the end of her life. So we handled, the behavior, the medication management, and then the hospice aspects of it as well. Shortly after that, my mother and my stepfather also had a combined financial and health crisis. And it was a really rough time for them. And so knowing what I knew, I stepped in, helped them keep the house, sort out some taxes, prevent bankruptcy. And at the end of all that, I thought, someone told me about this profession of being a professional fiduciary. And so I thought, okay, well, let me look into that. So I got licensed as a professional fiduciary. Along the way, I became a national certified guardian, which is more of like a nationwide designation that says the same thing. It's more the general ethics of being a fiduciary, where you would help someone in court through a conservatorship. And then I also became a certified senior advisor. And I became licensed as a fiduciary, and then I decided that I felt more of a reward by helping people who had been where I was, who I could go back in time almost and be the person that I wish had been there for me to navigate and help me navigate through a really confusing time when I was next to the hospital bed that my father was in, researching, Googling in the middle of the night, trying to figure out all the things that Mika just explained. I didn't know them at the time. And so now I decided to consult rather than directly manage people's finances and affairs. So I started Setup Care, which is my consulting practice, and we help you manage and be the fiduciary essentially. And so you'll see a bit more what that role entails. But a quick way to explain it is that it's the financial, administrative, and coordination challenges that generally come with caregiving. I work on a per hour basis. I don't take referral fees. And a key aspect of what I do is working with the team of professionals, either that you have established or helping you establish a team. So walking backwards, as I said, Mika did a great job of explaining what you need to plan for and how you would plan for. But then who executes that plan? And Mika did allude to the professional fiduciary, and that's what I'm going to get into now, is this question of who carries everything out. We'll also get into later, what do you do if there is no plan, if there wasn't a chance to have a plan. But here is a really common tale, unfortunately, is that Bob and Betty, so they have 2 children, and they went to the presentation that Mika just did, and they went to their attorney and they set up a trust. They did exactly what they were supposed to do. And they thought, you know, when our children need to step up, it's going to be a really difficult time. So why don't we make each of them a co-trustee and of the trust? They can both manage it together. They can do some tasks here, and they sign off on everything together, and they're supporting each other administratively and emotionally through crisis and ultimately a loss. But life doesn't always go the way that we planned. So years later, after happy marriage, Bob passes away and Betty needs full-time care. The problem is, as they grew up, the siblings had a bit of a falling out and they don't really agree on anything. And then of course, when questions about care and money and inheritance come into play, whatever disagreements there are generally, they tend to get a lot worse. So Bob and Betty, they planned ahead. They had the documents they were supposed to have. They bought the house at the right time, at the right place in Silicon Valley, let's say. So the money was there. That was their plan, was to use their main asset to fund care. But the siblings couldn't agree on what to do. And I actually have a case right now that's like this, where unfortunately there is a house that's worth a significant amount of money. And I'll go to the next slide. There is the house and it's in the trust. It has a significant amount of equity in it and it needs to be sold. But the siblings, they need to clear out the house first. And they don't want to see each other. They don't want to both be at the house at the same time. They're disagreeing about who should sell the house. They're disagreeing about what should happen to the money afterwards. How much should be spent on care? How much should be invested? Stuff like that. But the problem is Betty still needs care and the cash is running out. So somebody needs to sell the house and it needs to be sold soon. So you could put the best option almost always is to put a neutral party in place before anything goes wrong. And this can be for anyone. Anyone can put a neutral party in place who is a professional that is trained and knows what they're doing. And the other option is to find a guide if you or your family member would prefer to handle it on their own. And so going back to the professional aspect, I'm going to talk about a professional fiduciary like Mika started to mention. And this is when this is someone whose only job it is to follow exactly the instructions that you leave in your legal documents, whether that's your trust, your power of attorney documents, your advanced healthcare directive, your will. They are there to follow the instructions. They have a legal and ethical obligation to do it. You do have to pay them, but in exchange, there is no admin that falls on the family members. So it shifts that away from them. It reduces the risk of conflict and stalemates. So in the case that I mentioned, if there was a fiduciary involved, there's a neutral party who could help with sorting out the possessions in the house where both siblings wouldn't have to be there at the same time. And most importantly, they have no emotional stake in the situation, and they simply have a professional and legal obligation to you. And fiduciaries are bound by really tight codes of ethics. And we also work together as quite a big community, and I'll explain a bit about that later on. But so the next question is, you may have heard the term fiduciary before, and if anyone has worked in finance or done a lot of work with finance in the finance industry and investing industry, you might wonder, well, what's the difference between someone who has a fiduciary obligation or is a fiduciary that they say, and this term of a professional fiduciary? So it does get a bit confusing, but for a good reason. The term fiduciary essentially means someone that you can trust, and it comes from the Latin word for trust. And like I said, it's often used to describe someone who manages money and who has responsibility over that. But if you've never heard of a professional fiduciary, that's okay. Most people haven't. As a licensed and regulated profession, it is still very new. It's less than 30 years old in California. And nationwide, there are many states which don't have professional fiduciaries. No one knows what the term means. There are a bunch of other terms. There's patchworks of who does what. And so California is not only on the cutting edge, but even for California, it's completely, relatively speaking, it's a new profession. So professional fiduciaries are regulated and licensed in California. That's great. We're one of the few states who do that. So you must be licensed. The official title is a California licensed professional fiduciary. And someone who holds themselves out as a professional fiduciary has to be licensed when they are managing the affairs, either whether that's through a trust, through a healthcare directive, under power of attorney. They have to be licensed if they're doing that for multiple individuals that they're not related to, and especially if they're receiving money for it. The same goes for people who are doing conservatorships. We also have to be trained, so we have to go through a state-approved program, and then we have to complete continuing education every year. It's actually quite a bit of continuing education. It's half the length of the program that we have to go through. So I'm always on a webinar, I say, because I have to fill out those credits. But it's really good because we do learn a lot, and it is a giant sphere because you're essentially stepping in for somebody else. You are being that other person. And so you have to know everything that they would need. We are supervised and regulated, overseen by the Professional Fiduciaries Bureau specifically. There are several ways to make sure that you're talking to the right person. So what can they do exactly? So normally managing financial affairs, that's the biggest one, the standard bread and butter. So that's handling bills and not just helping you organize them, but actually paying them through accounts that either you set up or they set up. They can manage your investments by working with an investment advisor almost always. They can handle your taxes, usually by working with a tax attorney or an accountant. And they do all of this either as your trustee or under some form of power of attorney or a conservatorship potentially. They can make the healthcare decisions when you're not able to, and would follow what's listed in your advance directive as much as possible. Like I said, they can step in as a conservator, and that is usually a preferred option in really complicated cases where there is some family dynamics at play. And so after you've passed away, what happens then? So a fiduciary would locate and protect your assets. They would handle your real estate, whether that is preparing it for sale, preparing it to move on to the next generation, actually selling it, or sometimes managing it as a rental property along with a property manager for years to come, depending on what you've chosen. They'll distribute your possessions and what you've decided to be passed on to your beneficiaries and heirs, either through the will in probate or through the trust. And they'll make sure your final wishes are honored according to your advance directive or what you state otherwise. Whether you want to be cremated, follow a specific religious ritual, or work with a specific religious organization, that is what they're there to do. The professional fiduciary is there to help make sure everything is followed to the letter. Who might need a professional fiduciary? So everyone can have a professional fiduciary, but there, as Mika will tell you, there are some cases where you really probably need to seriously consider a professional fiduciary. So if you have some very specific wishes, that's probably a case. If you have a complex or large estate, or an estate that may have tax considerations, there are a lot of pitfalls that can happen there, and professional training and experience really comes in handy. If there are strained dynamics that could lead to conflict, or if you worry that people might end up in court, that's also when to consider a fiduciary ahead of time. And if you're a solo ager and your family lives far away and there's no one who could step in down the street, then you can find a fiduciary who lives nearby, who is there to basically be that person, to be that family member when you need help. You can find a professional fiduciary. I always say start by asking your estate planning attorney. They usually work with professional fiduciaries. They have fiduciaries that they trust. The referral always helps. There is the Professional Fiduciary Association of California. They have a searchable directory of licensed members. Not every fiduciary is a member, so it doesn't cover everyone. Sometimes their tool doesn't always work, unfortunately. I'll get to it at the end, but if you're looking for a fiduciary and you're not sure where to start, you can also email me. I can help you find one. So when you're interviewing a professional fiduciary, the most important question that I think people skip over is, do your values align with them? And I know maybe it sounds silly, but do they respect your religious values? If you have political beliefs that are very important to you, are they in tension with those? Do they have the same priorities as you in life and value the same things? Do you want someone of the same generation? That's extremely important. Maybe even more than that, just that they know how to do everything. You want them to know how to do everything, but you want them to do it the way that you have asked and to be respected. You want to ask them if they've seen a situation like yours before. Sometimes they haven't. If the answer is no, that's not necessarily a red flag. You want to hear how they're going to deal with that situation. Are they going to seek out a specific type of attorney? Are they going to consult with more experienced fiduciaries on a general anonymous basis to figure out what to do? There are so many situations that can pop up. You want to know how they're going to handle whatever comes their way. Another important thing is what happens if something happens to them. So how close are they to retiring? If you're looking for somebody to manage a trust that goes on for 20 years, you probably want to think of another option than someone who's going to retire in 5 years. And just as important as the person who goes in place first, you want to know who their backup is going to be. So you can hire and name one fiduciary as the main successor in your documents. And then if something happens to them, you could already have vetted someone else that you chose as your second choice who would step in. Professional fiduciaries, unfortunately, it is a very needed service, but it is not free. And it can get a bit pricey. The average rate that I've seen across the state is between $150 and $275 an hour. I am starting to see some fees inch towards $400 an hour for people who do very specialized work or who have been doing this a very long time. But I would expect to see around 150 to 275, depending on where you live. If you live in a wealthier area, they're going to charge more. If you live in an area that is a bit more agricultural, say, and there isn't as much business, they'll charge a bit less. You want to know if they're going to charge a percentage of the assets under management. Sometimes they'll charge 1% or even maybe more. You want to ask and have the fee conversation early, but I will say we are required to post fees on our websites. And as a result, fiduciaries are very open about what they charge. Another consideration, and this is a question that you would want to direct if you're working with Mika, would be how much you would probate cost, because probate does have statutory fees, but then fiduciaries also often charge fees on top of that for what they call extraordinary actions, extraordinary fees. So if we go back to Bob and Betty, if there was a professional fiduciary in the middle, we could say there's a neutral party who manages the trust and finances. So Betty's care would get funded. The house gets sold when it needs to get sold. Neither of the two siblings have to be there at the same time to sort through possessions, or if there was already a plan for the possessions, then they didn't have to do anything. The professional fiduciary can have them packed up and sent over to the other siblings. And the family can focus on what matters, because it's not always about a family that's disagreeing with each other. It's if you take out this possibility for disagreement, if it's handled by somebody else, the family can focus on supporting each other through what is almost certainly a difficult time. But life isn't always that simple. And I'm going to start talking about what I do more. And it's not just that you have to work with somebody like me. It's also that there's more to planning ahead than just the legal documents. And then there's also what you do when the planning window has passed. So if you have the legal documents and you want it to stay in the family, but they've never done something like this before, there's still options. If you didn't have a chance to plan ahead and there's a crisis, or maybe a fiduciary isn't practical for cultural reasons or not affordable or just not available in the area, there is still a way for you to handle things. And so that's where elder care strategy comes in. And I like to say that I'm breaking ground here a little bit, because I am a licensed professional fiduciary, but I try and help you be the fiduciary for your own family, or your family member or friend be the fiduciary, so that they get the expertise that I have. And a key part of this, just generally, even if you don't work with someone like me and you're thinking ahead, the benefit of having strategy versus sequential action. And I say sequential actions because a common instance is when a parent will end up in the hospital, and on day one, the doctor says they need 24-hour care. No one really explains what that means. Someone gives you a business card to a placement agent, then you're told that your parent needs to be placed somewhere, or your spouse needs to be placed somewhere. You tour a few places that maybe they were down the street from Trader Joe's, but you never noticed them and you've never heard of them before. Then you realize when you're about to sign documents that you need a lawyer, and you need to find a lawyer who's going to help you with this. And then you're not sure where the money is going to come from. Do you need to sell the house? Should you keep the house? And you don't need to figure everything out on your own, even though it is unfamiliar territory. And that's where I was. I didn't know anything that I was doing. And so I say strategy is planning before a crisis, and also turning the crisis, the chaos, into a step-by-step plan. So when you have a strategy, either that someone made in advance or that someone is helping you with, the person in the middle of it can focus on one thing at a time. They can focus on touring those places because they know someone has already considered when to talk to the attorney, which attorney to talk to, who is going to sell the house, like Sophie, and already put you in touch with them and working to help you in the background. And I say strategy as early as possible is always the best. So from an elder care strategist standpoint of view, if you're in the middle of crisis, I would help you figure out the biggest priorities and plan really what is that next step. That's usually the biggest question. What do I do now? And what isn't important? If you don't know who to talk to, I can vet people or find people that that are vetted, that I've worked with previously. And a key aspect of what I do is trying to match personalities. And there's also accessing the resources you would need for care. So I know I'm running a bit out of time, but I'll just move through these quickly. So strategy is for every situation. You can put a strategy in place ahead of time for your family member or friend to help them avoid the pitfalls, even if there are complicated or strained dynamics, if you're a solo ager, or if there's no plan and something has already happened. And this is including if a fiduciary is involved. So you can look ahead of time to find the right fit, and really invest in that process. And then someone can work with your family later on to guide them through what to expect and how to work with a professional fiduciary. And then everyone works together. And so Sophie is your real estate expert. She's going to help you with the house. Mika is going to help you put the documents in place and help you manage the legal affairs. The professional fiduciary is going to follow your instructions. And whoever is at the middle of it all, your family member, your friend, whether even if they are working with a fiduciary, what I try and do is to help you and the family stay safe and to navigate everything without having to worry about all this confusion of this of whatever crisis you're in. And moving a bit backwards, it's never too late to plan ahead. Please, 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 what you should do now is you should find whatever documents you have. You should review them. And then when you need revisions, you should call Mika. You should call her right away. And so even if everything looks good, but they were still a few years ago, if you did this 10 years ago, 20 years ago, please call Mika anyway. Things have changed. She will tell you that you will thank yourself later on. Please call Mika. And if you're not sure where to begin, you can always call me. You can ask Sophie. You can call Mika. Professionals like us, we have referrals that we can send you to. And so that's all I have. I know we're running a bit out of time, so this is my contact information. If you have any questions that we're not able to answer here today, the best way is to email me at hello@setupcare.com. And to put it in a nutshell, I provide strategy for every care situation. Any question that you can have, I will help answer. And if I can't help answer it, I will find someone who can. And that's all I have today. Thank you very much.
Thank you so much, Avery. That was a lot of information, just like Mika's presentation. A quick question, what areas do you service?
So I work remotely only, and as a result, I serve everywhere. My specialty, of course, is California. That's where I'm licensed. But a few weeks ago, I was helping somebody in Missouri find resources. So wherever someone is, I will help them find what they need to find and help them figure out what they need to figure out.
Great. And as Avery said, the elder care, if you have questions, reach out to him directly. Any real estate questions, feel free to reach out to me. Legal questions to Mika. And Mika, I ignored to ask you the question, what areas do you service?
Thank you, Sophie. I was muted across the state. So anywhere in California, we can go to San Diego. I mean, not physically go there. Of course, we can meet via Zoom, but we do have clients all over the state of California. And clients actually sometimes are residing in different parts of the world, across the United States and different parts of the world, but they have ties to California. Sometimes they have their parents' properties in California, so we're not limited only to clients who live in California.
Great. It's really just fantastic speakers today. And I want to thank everyone for joining us. And please watch out for upcoming webinars. You have any questions, feel free to reach out to Mika or Avery. And if there's anything else I can help you, please reach out to me. We're here to help. Thank you very much. And bye now.